Michael, good to see you again. Tell us who you
Good
with.
to see you. I'm with the Southern Center for Human Rights.
Okay, go ahead.
And congratulations, Chairman.
Thank you. Appreciate that.
And happy birthday, Chair. I'm trying to speak on behalf of the Capitol Defense Bar. It's not an easy thing to do, but I will do my best. I want to thank Chairman Werkheiser, all the sponsors of this bill. And as you said, Chairman Smith, we've been at this for a long time, and I appreciate the work of this committee on this issue over the last few years. I'll try to keep these remarks brief so that I can answer any questions, and I've tried to confine my comments that they're responsive to what happened a couple weeks ago. But before we dive into the specifics, I do just want to take a step back regarding the impact of this bill. It's very important, but it's also very, very limited. According to the Georgia Department of Corrections, there have been over 150,000 people convicted and sentenced to prison terms in the last 10 years. About 3,000 of them were for homicides. And in that same time period, there have been about 90 death notices in the state. So we started at over 150,000. We're already down to just 90. And even of those 90, only about 10 of them claimed ID. So really, we're just talking about 1 or 2, maybe 3 cases a year. Of course, it's extremely important that we fix the problem for those cases, because the Supreme Court has said that people with ID face a special risk of wrongful execution. But we're talking about a tiny, tiny slice of Georgia's criminal justice system, and a tiny, tiny slice even of Georgia's death penalty system. And so I just want to keep that in mind as we talk through the impact of this bill. Now, turning to the language itself, there are, of course, 2 important changes, as Chairman Werkheiser laid out. It would change the standard of proof to from beyond a reasonable doubt to preponderance of the evidence. And it would separate the ID determination from the guilt phase of the trial and give the parties the option to have a pretrial hearing on the issue. I won't spend a lot of time on the standard this time because a couple of weeks ago the prosecutors said that they support changing the standard to preponderance of the evidence. That's very important, but it's not enough to fix the problem. Here's how I think about it. If the clock's running out and you're down by a touchdown, kicking a field goal is not going to help you. You're still going to lose the game. And the score looks a little better, but you haven't tied it. And that's all we're trying to do with this bill, is tie the game. And to do that, we have to change the process. Under current law, the jury makes 2 decisions at the same time: whether the person's guilty, whether the person has ID. And this bill separates those 2 decisions. And that's important because the U.S. Supreme Court has said so. A few years ago, they considered how Texas handled intellectual disability. And one of the things Texas did was they asked jurors to look to the facts of the crime and consider whether the crime showed evidence of planning or forethought. Basically, they asked jurors to think, do you think someone with ID could have done this crime? And the Supreme Court said, you can't do that. The facts of the crime and the question of ID are completely separate questions. Putting them together like this, and here I'll quote from the Supreme Court, creates an unacceptable risk that persons with intellectual disability might be executed. So in other words, if you separate those 2 decisions, you make them more accurate, and you lower the risk that someone with ID will be executed. And this just makes sort of common sense. The guilt phase of a capital trial should be focused on one question: whether the person's guilty. ID, that's a sentencing question. It's not a guilt question. Regarding the optional pretrial hearing, which is in lines 13 through 34 of this bill, and I don't think there's been a new LC, but I'm just for the 1378. A couple of weeks ago, it was suggested that the pretrial hearing would grind capital cases to a halt, lead to endless litigation, and that's just not the case. First of all, and this is important to emphasize, it's optional. Lines 19 to 22 say that the state can object to it, and the court can decline to hold it. So some of you might think, it's probably better for a jury to decide this. I think a lot of judges around the state might agree, and so they would just decide not to hold a hearing. So we want to let this go to a jury. This pretrial hearing is only mandatory if the state agrees to it. And there might be cases where they want to, as they've said to me privately. Maybe they want a preview of the defense evidence. Maybe they want to see how their expert holds up. Maybe it helps them in their negotiating posture. The point is that we're just trying to give the parties an option. And it's not slowing anything down. Capital cases have scores of pretrial hearings. They take years to bring to trial. There's a pretrial hearing on everything under the sun. Forensic evidence, jury panels, witness statements, you name it. This is the one issue where you can't even have an option of a pretrial hearing. And it just doesn't make sense. People with ID are entitled to more protection, but we're providing them with less. And it's just not efficient either. A pretrial hearing, when it happens, can simplify the case and save the state the expense of a capital trial and the appeals that would inevitably follow. Regarding those appeals, it was said that this would lead to endless appeals. And I thought Representatives Kendrick and Panage put this concern to rest. But I do want to add one clarifying note. Lines 33 through 34 do authorize a pretrial appeal, which would be new. But we added that at the request of the prosecutors when a similar bill was introduced last year. The only new appeal in this bill, in other words, is for the state. Everything else the defense is going to do no matter what if this case goes to trial and results in a death sentence. A couple weeks ago, nobody came here and said this, but I do want to address it because I've heard rumblings of it in other conversations regarding the retroactivity of the bill. This bill would not apply to anyone on death row. Line 108 explicitly says that the bill applies to cases that go to trial, quote, after July 1st, 2025. The Georgia Supreme Court has already held that changes to Georgia's ID procedure don't apply retroactively. Now look, might somebody on death row try to file something and say it should apply to me? Sure, maybe. But they would lose because the text of the law, the case law, they're both clear. And if anyone comes up behind me and says anything to the contrary, that this is going to open up death row, everyone's going to get off, please ask them to tell you what the case is that says that will happen. Because I don't think it exists, and it's my job to know if it would exist. The last thing I'll say before I take questions is D.A. Barksdale said recently that Georgia has never executed someone with ID, and we can debate that until we're blue in the face. I think the question for this committee isn't whether or not we have. It's whether there's too high a risk that we will. And this bill would ensure that we don't. Thank you for your time. I welcome your questions.
See no questions from the committee. Thank you for being back with us.
Thank you for having me.